It was one of Donald Trump's central promises in 2016, which he made over and over again on the campaign trail and to Marjorie Egan and me on Boston Public Radio when we asked if he had any litmus tests for Supreme Court justices.
We want good, strong, conservative people that are extremely smart. I'm pro-life, and I would put in pro-life.
With Justices Neil Gorsuch and Brett Kavanaugh now in place, could the landmark abortion law Roe v. Wade be at risk? Court just halted a controversial law from going into effect in Louisiana, which would require any doctor performing abortions there to have admitting privileges at a nearby hospital. And right now that's only true of a single abortion clinic doctor in that state for those keeping track. But the decision was only temporary, and the vote was 5-4, with the typically conservative Chief Justice John Roberts joining the liberals. And that fact has both sides celebrating, with pro-choice forces cheering over Roberts acting as their swing vote in their favor, and pro-lifers celebrating what may be still to come. So could this be the beginning of the end of Roe v. Wade? Joining me are Renee Landers, Suffolk Professor and constitutional law expert. Good to see you, Renee. Kevin Martin is a partner at Goodwin Procter, once clerk for Supreme Court Justice Antonin Scalia. It's great to see you, Kevin. Thank you so much for being here. Hey, can either side claim victory, or is it really too early to tell in this Louisiana case?
I think it's way too early to tell. This was just a procedural decision by the Supreme Court, and I think that Chief Justice Roberts was really, really making it as a procedural decision and deciding on something that looked. His decision looks square with existing precedents. So he's a justice that follows precedent. So
but let me be clear here. You first said a procedural thing, and then you said following precedent. So can people read something into Roberts' siding and making the majority with the four liberals, or is it just a preliminary?
It's a preliminary read, but on the procedural question, I think it was a good call on the precedent.
Do you read anything more into it, Kevin, or no?
I really don't. There was a very similar case out of Texas that was decided 2 years ago, also involving admitting privileges at hospitals. And so in this case, Louisiana basically said, hey, we have some different facts in our state. Maybe our case can come out differently. And I think, as Renee was saying, that the Chief Justice basically just put a halt to the law. It's similar enough to the Texas law that was struck down. And so this will give some time for factual development to occur.
But when you compare Texas and Louisiana laws, as you say, Texas was struck down, is the real difference in the laws, or is the real difference in Justice Kennedy was sitting on the Texas case, and now Justice Kavanaughh is sitting on the Louisiana case? That's a pretty significant shift, is it not?
Not for this particular case. In fact, Justice Kavanagh had a dissent from the stay order, and what he said in his dissent was that the state of Louisiana actually agreed that if it turns out those additional doctors, and there's only a handful, can't get admitting privileges at a hospital, then Louisiana would agree that the law was unconstitutional. So it just comes down to what the facts on the ground actually are.
Does that worry you, what Kavanaugh said in his dissent, saying, let's see what happens? There apparently are 3 other doctors who are performing abortions, and then theoretically they could get admitting privileges. A lot of nervous pro-choice people say that's not the way to determine whether there's a constitutional imperfection here.
I agree with them. I think Justice Kavanagh, with all due respect, has the law wrong. He needed to have factored into his analysis whether, in fact, this regulation in Louisiana had any medical benefit in protecting the health of women at all.
Apart from whether those 4 doctors will all be admitted.
Exactly.
You know, I have to say, I'm almost intimidated when talking to you two about these kinds of things, but I'll plow ahead anyway. In the Planned Parenthood versus Casey, my understanding of that from 92, I think it was 92, basically said states are prohibited from placing undue burdens on a woman's right to get an abortion. How can ending up with potentially only 1 doctor in a whole state not be an undue burden on a woman's right in Louisiana?
And that's where Justice Kavanaugh in his dissent said that Louisiana agreed that if it does come down to 1 doctor, there would be an undue burden. Where you really have a conflict here, though, is that most Americans, I was looking at Gallup poll data before coming on tonight, think that there should not be a right to an abortion in the 2nd trimester. It's almost 2 to 1. What Planned Parenthood versus Casey said was that the state has almost no ability to regulate abortion in the 2nd trimester. And so in states where you have a pro-life majority like Louisiana or Texas, they're going to push the boundaries with laws like this one because it appeals to voters in those states.
You know, 70% of America didn't believe in interracial marriage when Loving was decided, too. So I assume you would agree that shouldn't be the determining factor.
Times change, but when you look at the Gallup poll data, this is one where it's been fairly constant since the 1970s.
You know, Susan Collins, who made that impassioned, I think, 44-minute speech, obviously a senator from Maine, in support of Kavanaugh, said she trusted that he respected precedent, and it was based on, I guess, a couple things. One, her interview with him, plus something he said at a hearing in September of last year, obviously during the confirmation process. Here was then Judge Brett Kavanaugh. Here he is.
As a general proposition, I understand the importance of the precedent set forth in Roe v. Wade. It's settled as a precedent of the Supreme Court. It has been reaffirmed many times over the past 45 years.
Is there anything he said in his dissent that ran afoul of what he said to the senators in the country in that hearing?
Not directly, but I think he has this subtle revision of the test that the court articulated in Casey about the undue burden test, the application of the undue burden test, because he does not factor in whether there's any medical value to the restriction that the state is seeking to impose. That is a backdoor way of allowing states to impose regulations and to try to weaken the undue burden test.
You're saying that undue burden is in part based on, to satisfy it, there's got to be at least a medical or a scientific basis. Do you agree with that, by the way?
As a constitutional matter or under Planned Parenthood versus Casey?
Well, either.
As a constitutional matter, no. But again, this comes down to the conflict in the second trimester, and what the court said in Casey was you need to have some kind of medical necessity that does not jibe with what most people in most states believe.
You know, I should know this.
At that point.
But why did your former boss, what was his argument for why Roe v. Wade should be reversed? I should know this, and I don't.
Well, just that it was wrong from the outset.
That there's no right to privacy, or is that was?
Yeah. Well, now you start going back to the 1930s.
But then you're going back to the cases
Roe v. Wade,
in the 60s and the Griswold v. Connecticut, which doesn't allow states to ban contraceptives.
So it'd be better if I don't ask the question. Is that what you're saying? I think that's probably true. Can we step back for a minute and discuss? A lot of people who are pro-choice believe the real agenda, if I may use that word, vis-a-vis pro-life advocates and those who believe Roe v. Wade was wrongly decided on the Supreme Court, is not the repeal of Roe v. Wade for fear that it could lead to a small R revolution, but death by 1,000 cuts, like a Texas, even though it was struck down, or like a Louisiana. Do you subscribe to that notion?
I totally do, because since in recent years, I don't want to say the last 5 years, there have been record numbers of regulations trying to limit abortion procedures passed in some states, and I think that that's going to continue. I think that Kevin is absolutely right that a state like Louisiana is going to try to push the envelope to find out where the boundaries are on whoever's on the Supreme Court.
Do you agree with that?
Now.
I mean, like the heartbeat bill, I think it was in Ohio that passed, that said as soon as the heartbeat is in the fetus, which is as early, I think, as 6 weeks. Is that the route that you think the court's ultimately going to take?
So a lot of the decisions are based upon facts particular to a case. So the Texas decision, right, from 2 years ago, relied heavily upon facts particular to Texas. A state like Louisiana is going to say, our facts are different, so let's test those boundaries and see if slight differences in the factual backing result in a different outcome. So like the heartbeat bill, they'll test that. There'll be continual tests.
So can we get back to this Louisiana case? Ultimately, do you see the court using this case to repeal Roe v. Wade?
Well, not at all. I mean, so the Chief Justice Roberts actually voted in support of the Texas law, but then switched effectively his vote for this Louisiana case. And again, the Louisiana case is focused on this very narrow issue of hospital admitting privileges. It says nothing about whether there's a right to abortion, generally speaking.
Are you as confident as Kevin is about?
I don't think this is going to be the vehicle for overturning
Why do you not?
versus Wade for the reasons that he said. I think that it will be a too dramatic a shift for the court to impose.
Do you think the court is looking for a case where they can repeal Roe v. Wade?
I think people are going to keep serving them up. States are going to keep serving them up, just the way this case has come up. And I think well, I'll just
Can I
leave
ask
it
one
there.
more Nostradamus case a question of you? A lot of people who are nervous about the repeal of Roe v. Wade say the justices won't stop there, that ultimately the goal, because obviously if Roe v. Wade is repealed, every state makes its own decision.
Right.
They believe that the ultimate goal of people who don't agree with Roe v. Wade is outlawing abortion in all 50 states, maybe under the 14th Amendment or something like that. Do you
that's completely unrealistic. And I would say, too, Chief Justice Roberts is an incrementalist. He is not going to, on a 5-4 basis, overturn such a well-known decision which has been in place for 45 years.
Kevin, it's good to see you. Thank
too.
you so much. Appreciate your time,
Great.
Renee, as always.
As
Really
always,
appreciate
good
it.
to
And
see you.
thanks
Thanks.
for braving the wilds to come here. I really appreciate it.